was reminded of the times when I was an assistant U.S. attorney when we had a very vigorous judge. When he finished one case, he would call the next one whether or not we had subpoenaed the witnesses for that day. I had some of the same problem today that these panelists did not know that I was going to be calling for them early, so we had a few minutes to round the panelists up because they had not planned to be here until 10:30, and we thank them for being here, and we thank them especially for starting early. When we planned this conference, we came up with a theme very early on of the past, the present, and the future in the D.C. Circuit. The past, we looked to the Historical Society of the District of Columbia Circuit to put together a program on the significant event in the history of this circuit. I want to say just a little word about the Historical Society before we begin with the panel. 2010 marks the Historical Society's 20th anniversary, 20 years since then Judge, now Justice Ruth Ginsburg, and then Chief Judge Patricia Wall first talked about creating an historical society for the D.C. Circuit. First order of business, they agreed, would be a board of directors. The newly incorporated society was headed by Daniel Gribben, whose name you've heard already today. He turned to Jeffrey Morris to compile a history. Well, since that time, the rest is history. The Society has regularly produced interesting and informative programs. Those programs have culminated or will be typified by this Who Solved Watergate panel that you'll be hearing today. The biographies of all the participants are in your papers, and I will not belabor the history of Professor Carl Stern, who will be moderating this event, but it will suffice to say that he was an award-winning journalist for his coverage of the Watergate and has covered many other historical events related both to this circuit and to D.C. over the last 33 years, I guess, of media coverage. I have one more thought about history and about the society and about this panel before I turn it over to Mr. Stern. It is not to know what happened before you were born is to always be a child. I think traces back to, I guess, Cicero. It strikes me today that many of you, perhaps, Watergate happened before you were born. So for some of us, we will be reminiscing today, the panel and some of the rest of us. Some of the rest of you will be refreshing your knowledge of history or perhaps learning things about history that you certainly couldn't have read in very many books. Without further thought on that, then, Carl Stern will be presiding over the panel. Professor Stern.
Well, thank you, Your Honor. I don't have to tell anybody about Watergate. I hope I don't. We're going to start right in. No preliminaries. Earl, I'm going to go to you first. Where are you? Earl, you're first. You were the U.S. attorney, right?
No, I was the principal assistant.
Principal U.S. attorney. Okay. But
I was not the U.S. attorney.
You could have been on the cover of Time magazine. Okay? Did you expect Judge John Sirica to become the Grand Inquisitor?
Oh, I wouldn't put it that John Sirica was the Grand Inquisitor. He was doing what he thought to be right as a federal judge. He had very strong views as to integrity in the court and to right and wrong, and he did what he thought was right.
Richard, you were one of the two Sirica clerks, Richard Azzaro, and right from the beginning when Judge Sirica refused initially to accept Howard Hunt's plea on 3 counts, the judge said, the court has a duty to get the facts out. And he wrote, I had no intention of sitting on the bench like a nincompoop watching the parade go by. Bit of an understatement.
That's classic Judge Sirica.
Well, was the judge right to butt in that way?
Oh, I don't think there's any doubt in my mind, and I'll take my first point of refuge in Judge Leventhal's opinion that spoke about Judge Sirica's conduct. And he said it was in the best traditions of the court. So his conduct overall, I just submit, he was not a Grand Inquisitor. As Earl points out, he had a profound sense of respect and loyalty to the integrity of the court. But driving all of this, I think a principal driver for the judge was that there be fairness in the trial. And so what he did, as Earl points out, was in keeping what he thought was ensuring a fair trial, and most importantly, especially in our times, you recall the times were very difficult times. We were finishing up Vietnam. We had the assassination of Dr. Martin Luther King. The institutions of the federal government are under attack on all points, and the federal judiciary itself was questioned as to whether it should be independent. So we go into this incredible thing we now know as Watergate. We had dynamics that had not been seen ever. I don't think ever. But so that's how the judge enters this, and that's the kind of guy he was.
Well, each of you feel free to jump in, but Earl, isn't it the prosecutor's job to present the case?
Well, yes. As I said, Judge, in my view, did what he thought was right. We had, the prosecution team had some differences with him in that case. We had, early on in the investigation, come up with a strategy that we wished to pursue, and that was to go as far as we could with the evidence that we could uncover, conducting as intense an investigation as we were able to do, but eventually we ran into a roadblock. There were 7 persons under investigation, and in that situation you often hope or anticipate as a prosecutor that one or more of them will decide it's in his or her best interest to cooperate. There was no cooperation here. I approached each lawyer for each defendant and raised with them the fact that we were coming after them. We were going to planning, hopefully the grand jury would indict them. We would bring them to trial. And the next step, and this was critical, was that with the record complete, we would be in a position to use what was then a new statute. It had only been enacted in 1970, the use immunity statute. It had been its use was very limited, but there was a recent decision down in the Fifth Circuit that indicated you could grant immunity while a case was pending on appeal. And that's the way we decided as a matter of strategy we were going to go. As I said, we let them all know that's what we wanted to do. And it was very important, 2 things. One, that the trial record be as clean as possible so that the defendants, if convicted, would not think they had a chance to prevail on appeal. And number 2, that they would be aware that if convicted, they might well anticipate a fairly significant sentence coming from a judge who, at least by reputation, was a tough sentencer. So that was the strategy that we tried to put into place. The difference that we had with the judge, and I particularly had a difference with the judge, was that it was our view that with the indictment of the 7, the purpose was to try those 7 in the courtroom and hopefully obtain a conviction, which we thought we would do based on the evidence that we had put together. Having the judge, this is my perspective going back about 35 years as to his view of what was going on in the courtroom, thought that more of the evidence would come out during the course of that trial. And that's where we had a difference. Our view was the investigation takes place in the grand jury. The guilt or innocence of those who may be indicted by the defendants takes place in the courtroom. And in conjunction with that, we didn't want to mar the record or in any way do something in the record during the course of the trial that, as I said, might wind up or give the defendants a basis for thinking they could put off the day of reckoning, being granted use immunity and compelled to testify. That was the strategy. And that was the difference that we had, Carl.
Everybody will get a chance, but Earl, let me pick on you just one more question. Sirica even brushed off your attempt, to examine Hugh Sloan. Sirica had examined Hugh Sloan out of the presence of the jury. And then when he recalled, when Sloan was recalled for examination in front of the jury, he brushed off your attempt to do the questioning of Sloan. And in fact, he even overrode the objection of Gordon Liddy's lawyer. What do you think of that? The judge saying to the prosecutor, "Never step aside. I'll handle this myself."
Well, that was.
But yeah, in all fairness, the judge didn't say step aside.
Yeah, that's my.
He didn't say step aside.
Right.
He had a record in front of him, and he was not happy with that record for a number of things. And the first thing you got to remember about Judge Sirica, this was a man who had tremendous trial experience and been on the bench for quite a while. He was not happy, as using that term. He was not satisfied with what was happening in his court, so he embarked on that line of questioning. At that point, then
wait a minute. He thought Earl couldn't do the job?
Never in his mind did he ever think that Earl Silbert could not do the job. He had the greatest respect for Earl Silbert, and Earl never did anything to diminish that. No, not at all. It's just that he was not happy. I think maybe the word that's starting to crop up here that may deserve further look at is this worry about error. If Judge Sirica had a hallmark about him and the way he approached things, he did not, as he would say, I don't have my eye cocked up to the upstairs to worry about if they're going to reverse me. He always pursued what he thought was fair and what needed to be done, again, for the trial, for the safety of the defendants, that they get a fair trial, and the integrity of the court. I think that's the part that has to be emphasized. And the judges, that's another, he's gotten a bad rap for that, excuse the expression, but that idea of Judge Sirica wanting and taking the limelight is really an unfortunate development, a sideline of the whole Watergate affair. It starts with him, he didn't want to take the case. It came to the point where he was the only one who could take the case. And that's when he assigned it to him. And I was with him too closely many times where his own physical security and his own health was jeopardized, and he wouldn't quit. But it wasn't for limelight. Okay. It was not. No, definitely not.
Earl, did you answer my question? Were you upset that the judge is taking the questioning away from you?
It had been a difficult investigation. We were concerned ourselves about what was being told to us, what was true, what was not true, what was shaded, what was not shaded. As prosecutors, we made a judgment. I made a judgment that Hugh Sloan was a credible witness, and we were going to, in the course of the trial, place great reliance on him and his integrity and honesty. There were other witnesses there about whom we had some reservations. Not hard evidence to indicate that what they were saying was not true, but at the same time, just concerns and worries. So it was kind of a little troublesome to us in view of the strategy that we had, that Judge Sirica was apparently dissatisfied or at least questioning the testimony of Hugh Sloan, whom we thought, among all the people we were talking to, was a critical, important, significant witness to try and obtain the convictions that we were seeking.
Okay, Rick Ban-Veniste, you are a trial lawyer, okay? Here's my question. After the break-in trial, after the first trial, once Judge Sirica had become so identified with the aggressive pursuit of this matter, should further proceedings in the Watergate succession of proceedings have been handed over to some other judge who was less identified in this matter?
I don't think so. Judge Sirica did play a critical role in the advancement of the truth about Watergate. He was dissatisfied with the fact that people had lied in his courtroom under oath. He was dissatisfied, clearly, with the story that had been concocted that Gordon Liddy was the top of the food chain, that Liddy was the one who decided to divert funds from the committee to re-elect the president and spend them on unlawful purposes, including the break-in and bugging of the opposition party, the Democratic National Committee headquarters. And so I always thought of Judge Sirica as playing a unique role, perhaps unique among all the judges at that time who were sitting in that courthouse, in terms of getting to the truth of Watergate. And given his background in the case and his familiarity with the facts and the personalities, I didn't have a problem with the judge as chief judge, as it was his prerogative to continue on and assign the case that we brought, the Watergate Cover-Up case, prosecuted by the Special Prosecutor's Office, building on a tremendous amount of work that Earl and Cy Glanzer and Campbell had all done in the U.S. Attorney's Office, and picking up the threads and advancing the case to get to the real heart of the Watergate, which was the cover-up, the use of the power of the president's office and his attempt to manipulate the CIA and the FBI and corrupt the Department of Justice. And have no doubt about it, the Department of Justice had been corrupted. Justice was obstructed. Henry Peterson, the chief of the criminal division, had been horribly misused by the President of the United States. Richard Kleindienst, who was the acting Attorney General after John Mitchell left the office, had important information from the day after the break-in, which he never disclosed to the line prosecutors, about who was involved when Liddy came out to visit him at Burning Tree Country Club. And so Henry Peterson, who was talking to Richard Nixon and talking to Earl Silbert, and in whom Earl properly confided as to the progress of the investigation, was giving that information to Nixon, who was sharing it with John Dean and Haldeman and Ehrlichman, the targets, the ultimate targets of the investigation. And so at that point, it was not inappropriate for Judge Sirica to continue on. And he as the appeal of the case that we tried demonstrated, tried that case without error.
Well, you just put your finger on something. John Dean, okay? John Dean decided to do business ultimately with Rufus Edmisten, who's sitting next to him, and the Senate Watergate Committee, because he came not to trust Earl Silbert's team, not Earl as a person, but a concern over information being transmitted from the prosecutor's office to Henry Peterson at the Justice Department, who in turn was passing information along to the White House. Have I misstated that?
Yes.
Okay, you stated correctly.
And I also checked for a piano before I came in, saw none, so I only sing typically in front of Senate committees, but today I'll make a little exception and keep the tune up. Anyway, what happened is Henry, and I'd known Henry from my days in the Department of Justice. He and I were good friends. Long after I became counsel, many times I'd had very sticky problems that had come up, and I didn't know what to do with them. So I went over and would see Henry. Henry would say, "John, you tell Colson that we're going to go after those union guys regardless of what he says. Once the FBI starts, it's over," so on and so forth. And so I would get this kind of advice from Henry, and we had this kind of rapport. When Watergate occurs, one of the first persons I spoke with after Kleindienst, who had been over at the White House, told me that Liddy had come out and said his men were arrested at the DNC. Would he get them out? And I had ridden back to the department with the Attorney General. He called Henry Peterson up. I spoke with Henry. Henry has testified, not quite to all of this, but to most of it. What I said to Henry, because the Attorney General then quickly left, and he had been confirmed by then, I said, "Henry, I'm not sure the White House can withstand a wide-open investigation. I had in mind by that time the fact that the White House had been involved in a break-in into Daniel Ellsberg's psychiatrist's office, which I had only learned maybe a few hours before. I also was worried about campaign contributions. Henry said, John, the only jurisdiction we have is the bugging incident at the DNC. The FBI will go no broader than that. We will not go into campaign contributions. That is the limit of our and the parameters of our investigation. I would then periodically have conversations with Henry. Henry really doesn't start talking to the president until after I have broken rank and gone to see Earl with an understanding with Earl that he and Seymour and Don will not take any information I give them back to the Maine Department of Justice, because I knew the cycle. It would come right back to the White House. Well, this worked for a while we had some very early explorations of how we might sort all this out. I had a theory that we might be able to go to the grand jury with this and deal with it there. I also came to a conclusion, and I think Earl did too, that there were limits as to what the U.S. Attorney's Office could do in all this. But anyway, at one point, they realized I had given them so much information and they were getting so much pressure from Kleindienst and Peterson to say that what was I reporting to them, that they had to stop our arrangement of privacy. And at that point, I stopped dealing with them and went to deal with the Senate, realizing that was be the forum in which we would work all this out. So the tapes show that I happen to have been right, that as soon as I stopped dealing with Peterson, the president himself started dealing with Peterson. I'd mentioned Peterson in many of our taped conversations, and Henry, as was not surprising, presumed regularity, didn't think the president was involved in these things, and indeed revealed much of what I had told Earl as to what was going on in some of the very early phases. We hadn't really gotten very far, and the cover-up really wasn't the focus at that point. So that's sort of the sequence.
But John, you hoped to gain an advantage, and you ultimately did, dealing with the Senate first.
No, I did not. My original intent was...
You did go to the prosecutors first, but you
go to the prosecutors and deal with it in front of the grand jury. I hadn't really thought through whether you could even prosecute a president. I didn't think it would go that far. I had a rather naive belief after talking to the president at one point, telling him there was a cancer on his presidency and he was in a whole heap of trouble, that my coming forward would result in my colleagues doing the same. That was a pretty naive belief.
Well, John, you have written repeatedly, let me quote you, that if the Watergate investigation had been left exclusively to the grand jury and to federal prosecutors, it would never have been satisfactorily exposed. Oh, those are my words. Nor even if it had been left, Barry, to the Washington Post. Didn't Judge Sirica's squeezing of the break-in burglars with these provisional sentences lead to the McCord letter, which in turn led to you to be convinced that the jig was up? In short, under that scenario, doesn't Judge Sirica get the major credit for breaking Watergate?
Is the question for me?
No, I'm going to send this to John.
Well,
wasn't it the McCord letter?
As a matter of fact, we fully anticipated
I'll come to you
McCord's letter.
next, Barry.
We fully anticipated McCord's letter. We had been told he was, in the vernacular of the time, off the reservation, that he was going to do something. When he did release his letter...
When Judge Sirica released it.
Yes, he went to Judge Sirica. Actually, Earl, my publisher has gotten me much to my reluctance, but now that I'm in it, I'm thrilled to be doing it, re-examining this material. I wrote a book called Blind Ambition about Watergate. I really have never looked at the overall problem. I was in some litigation for a long time where I looked at some of the memoirs and some of the testimony, but I'm really looking at it all now. And I discovered one of the most valuable documents is Earl prepared a diary almost contemporaneous of his activity. And there's so many nuggets in there of information. And one of the things that became clear is that they had their own scheme. Had McCord not broken rank, they would have kept pushing till they found somebody who did. But McCord is the first one who did it. When we read McCord's letter, the initial reaction at the White House, and this was sort of a moment of truth, if you will, is how much did McCord really know? All of his information was hearsay. He really only had what Liddy had told him and what he'd picked up from the other Watergate burglars, and that he did have the fact there had been perjury during his trial with Magruder, but he didn't go very far up the rank. His speculation that I had somehow authorized the Watergate break-in was baloney. I mean, that was just so far off the mark. Just a hunch he had. He tried to put the pieces together. So the moment of truth was, did we want to live the lie, or did we want to go forward and start unraveling this thing and deal with it? And to me, it was no choice. That was when I had made my decision.
So this takes away a little bit of the credit from Sirica for having forced this sequence of events through the provisional sentences and the McCord.
He was not in my mind.
Letter.
But Carl, I have to ask a question on this, because it's not so much to take it away from the judge, but by the way, I'd rather not use the word squeeze. I'd rather use the expression that he chained the beast down with law and reason, and started to show people by his conduct and the prosecution, which McCord was one of the 7, and that as he presented what he was going to be doing, how it was going, he frustrated all of the machinations that were being engaged in to defeat any further getting into the White House or following the Watergate up. But McCord's letter is more than just hearsay. I mean, there are, in my business, this thing called reliable hearsay, and hearsay allows you to get to another place. The way the judge handled that letter is indicative, again, not him seeking the limelight. He was intent on making the system work. The system was getting it out into the public and getting it to people like up on the Senate. And importantly, and this is a key role, is the press. The press got this, and things started to happen. And by the way, McCord wasn't that far off on the money. I mean, there were things he may have had hearsay on that he really didn't know, but there was money going on, and the whole thing was money, and McCord nailed that. They lied to the judge, they lied to the grand jury, they lied everywhere, and that's what McCord opened up. I think McCord's letter is a lot more than just some hearsay that it wasn't that much.
Barry, I want to pick up there, but give me 1 second, because Rick wants to put in a note.
Well, I would agree with that, and it was a seminal event because this was the first of the burglars to crack, and the first to acknowledge that funds had been paid by higher-ups to keep the original burglars quiet. And so the reason for this was a combination of the conviction and sentence that Judge Sirica imposed, and the attempt of the Nixon White House, the president himself, who was trying to lay the foundation for a cover story that would lead people to believe that the CIA was responsible for the break-in. McCord, remember, had been a CIA officer. He was, at the time of the Watergate break-in, as incredible as it may sound, the chief security officer for the committee to re-elect the president. And he saw the effort to misuse the CIA. Richard Helms, who was then director of CIA, refused the president's request to use the CIA to provide funds, covert funds, to the Watergate burglars, and was setting up a rather devious mechanism by asking Vernon Walters, who was the deputy director of CIA, to go over and talk to Pat Gray, acting director of FBI, to stop the investigation into the tracing of the funds found on the $100 bills found on the Watergate burglars, which would have led to the committee to reelect the president, and did eventually, but to obstruct the FBI investigation on bogus grounds that continuing the investigation would reveal CIA covert operations in Central and South America. And so McCord, being quite cognizant of what was going on, had threatened that he would get off the reservation. In McCord's words, all the trees in the forest would fall if the president continued in attempting to pin this all on the CIA, and that's what happened.
Let's put a date on this. We're talking about March 23rd of 1973. I need to get to Barry for a second. The day after the first trial ended, the Watergate burglars, okay? And we have convictions of Liddy and McCord. We got guilty pleas from Hunt and the Cubans, if I can call them that. The Washington Post, and Barry led the Washington Post coverage. Woodward and Bernstein worked for him, okay? The Washington Post had a story headlined, "Still Secret, Who Hired Spies and Why?" Okay, Barry, why wasn't why weren't the activities of Earl Silbert and John Sirica good enough for you? What did you want?
I don't remember that story, but let me just get in a little bit about Judge Sirica. Nobody can admire Sirica more than I do.
Closer to the mic.
I think that as the trial started, and as Sirica took the case for himself, there were natural questions about why he would do that. He chose to take this case. He then promptly issued a gag order, which was written by Earl Silbert, saying that to the effect that George McGovern couldn't even discuss Watergate in his presidential campaign. If the Post wanted to write editorials, it could, but it couldn't really do any reporting. So we had some reasons to be suspicious of Judge Sirica, but they disappeared quickly. I think Judge Sirica was what you might call a citizen judge. He looked at this, he was aghast at everything that happened in Watergate, and he was just not going to let it go by if he could do anything to stop it. If Watergate had been a trial of a civil rights group, like the Chicago 7 the year before, the Chicago 8, or whatever the number was, Sirica would have been in a lot of trouble by editorial writers. They would have come down on him hard. But this was an extraordinary case. Sirica knew it was an extraordinary case. He treated it like an extraordinary case, and he did, I'm convinced, as well on it as any jurist anywhere could have ever done on a case. So I think he was marvelous as far as that goes. Now, the fact that the trial ended with a lot not yet known, well, here's one reason that we might have been a little bit unhappy at the Post. Ban-Veniste talked a little bit about the money trail. On August 31st, Carl Bernstein talked to an investigator in Florida.
Talk about 1972, about 6 weeks after the break-in.
That's right. And we found out about money that had gone from a Nixon fundraiser to the Nixon Re-Election Committee. Ended up in the bank account of Bernard Barker, one of the burglars.
Money from Kenneth Dahlberg.
That's right, Kenneth Dahlberg. He lived in Minnesota, but he had been in Florida also. The investigators, Silbert and others, knew all about this, but we didn't know about it for a long while. And when Dahlberg confirmed to us that, yes, he'd raised $25,000, given the money over in a cashier's check so that it got to the Re-Election Committee, and from there it went into the hands of the Watergate burglars, well, you had a tie of, unlike any we'd had previously, between the Watergate burglars and the White House and the Re-Election Committee. So it was so clear that there was more to the story than had come out in the convictions of these and guilty pleas of these burglars. There was just not any question about it. The importance, one of the questions, the basic question of this conference, I think, is who solved Watergate? And the press gets a lot of credit for its work on Watergate. I think that it's exaggerated credit myself. I think my paper did a good job. But I think that what we were instrumental in was getting other things in motion. And that the story I just mentioned, this story tying the Watergate break-in, the Watergate burglars, to the Nixon re-election committee with money, with cash changing hands, was one of those stories. It was probably the single most important story we had because it gave birth to 3 investigations, Rufus Edmisten's investigation, and investigation by the General Accounting Office, and other investigations as well. So that was the press, the role of the press there was to prompt the workings of justice.
Okay, you got that, John? John Dean doesn't count. Barry's saying the big moment was 6 weeks later when the papers managed to show that funding for this break-in had originated with a check that had been drawn for the president's re-election campaign. Okay, I'll hold John for a moment. Go ahead.
Yes, if I can. I think what Barry just explained is one of the reasons why, or just demonstrates more than any other, the need to have the ability, which the grand jury provides, to conduct a very thorough, hopefully comprehensive, and an intensive investigation. And Barry talks about the check as being a key item, and there were actually 4 other checks that went through Barker's account. All of that came out. All of that, before the return of the first indictment, was explored in the grand jury. All the witnesses testified, Kenneth Dahlberg, Hugh Sloan, all the people that handled the money, and I'm sure my pros memo to the Department of Justice is a matter of public record, and I laid it all out and said there's coincidences here, but in terms of that check or that money having anything to do with the break-in in the Democratic National Committee headquarters, that didn't happen. Now, having said that, I'd like to talk just a minute and follow up with Barry's statement about the role of the press. Our investigation, and I think Barry would agree with this, was always ahead of the Washington Post. Of course, a lot of people were not telling us the truth. A lot of people were stonewalling, but we were trying to cover as many bases as we could. But later on, after the trial, as the investigation, John Dean came forward, partially, as he said, because of an accord letter. The same with Jeb Magruder, who came in a few days after John Dean to try and, they were seeking to protect themselves. They had very good lawyers who were looking out for their own interests, either not prosecute at all, grant immunity, or if you did prosecute as lightly as we thought would be appropriate. But so far as the role of the press was concerned, it did become important, not because of the investigative aspects, which it receives a lot of credit for. I don't think, as I said, we were ahead of them all the time. But they kept up a drumbeat of information, and by the time John Dean had talked to us, and John continued to talk to us after we disclosed to the Department of Justice, I couldn't sit on that information. I'm just an assistant U.S. attorney getting information about wrongdoing at the highest levels of the government. At that time, John is saying Ehrlichman and Haldeman are involved in very serious, not the president at that time. Right after the disclosure, we meet and have a secret meeting with John and his lawyer, who's a very good lawyer, and that's when John Dean tells us about the Ellsberg break-in, which was a huge disclosure, and explained or provided an explanation to us, because we were trying to figure out why would this group go into the Democratic National Committee headquarters. There's nothing there. There's nothing usually really of great value. It didn't make sense. But once they disclosed that this same group that had gone into the Democratic National Committee headquarters had also broken into the office of Ellsberg psychiatrist, and the authority for that venture went right up the chain, at least to Ehrlichman and possibly to the president. That gave us a reason to explain the motive, very strong motive, that the White House would have to stop our investigation because of what John properly noted was other things that might be discovered. The press, getting back to that one final point, Carl, we were 3 assistant U.S. attorneys just working that case. We had the support of the U.S. attorney, but our communications, for the reasons that have been specified by Rick and John, we were very concerned about talking with Henry. Not that I, for one, ever doubted his integrity, not for one moment. But at the same time, he had been compromised, and we thought that he would be a witness in the obstruction of justice investigation and planning toward an indictment that we were developing, and that he therefore should step aside. And we had some very difficult times at that point because he didn't want to step aside. In fact, he was dealing with the president, and that was an imperial presidency at that time. It was a great thing for him, and the idea of stepping aside was difficult. So one thing I did as an assistant U.S. attorney, I stopped communicating with Henry. I just had been sending over the grand jury transcripts. I stopped doing that. Now, when you think about and set self back, an assistant U.S. attorney cutting off communication with the Department of Justice, cutting off the Department of Justice communicating with the White House, that was kind of a little scary. But here's where the press came in. The press, to put it mildly, where the press came in by that drumbeat, they gave us a drumbeat of stories, keeping that issue alive. That gave us some cover. That gave us some protection because it was really almost impossible for the White House to, just fire or otherwise minimize or reduce our ability to conduct the investigation. And we were, as I said, talking to the highest level people, the chief of staff, the domestic counsel, the former attorney general. It was a constant parade, and no one was saying boo to us. And I think they were not saying boo to us because of the impact that the press was having on what was going on at the time.
Some quick points from John and then Rick.
Right. The point I wanted to make to follow up on both of these remarks is that as far as the White House was concerned, the news media never wrote one story, not one of the Woodward and Bernstein stories ever sent a chill up our back that they really knew what was going on. What they were doing, we recognized, was keeping pressure on the story, keeping the story as a front page story within the Beltway. The rest of the country couldn't have cared less about these events. It was the only place, the only paper that was focusing on it. Late in the game, Cy Hirsch of the New York Times does write the first cover-up story that really did send chills, and that was about the time that the Cuban Americans and Hunt were pleading guilty in Sirica's courtroom. He picks up the fact that they're being paid money. That did frighten everybody, that he was beginning to see that potential, and we figured that the prosecutors would be following up on that very shortly. I'm glad Earl also placed in context the Dahlberg Mexican money that the Post followed so aggressively so early and created this great $350,000 fund that Haldeman recalled, and would cause great consternation for Woodward and Bernstein, getting Sloan's testimony wrong, a scene that's all depicted with great drama in All the President's Men, because as Earl notes in his diary and just noted now, that money was just coincidental. It really didn't pay for the break-in. It was part of the lead, but it was not essential to their case or anything of that nature, and it did not play the role. The Deep Throat's famous comment, "follow the money," in fact, never happened, as Woodward realized. It's in none of his stories, and when Dan Shore pointed this out, that it was in the while in the manuscript and not in the book anywhere, Bob said, gee, I didn't know that. They really weren't following the money because the money didn't lead anywhere.
I wrote a hush money story and it went absolutely nowhere. Very quickly, Rick.
Let me second the notion regarding the press. The press was an accelerant in Watergate. It brought the attention, certainly within the Beltway and certainly to Congress, that there was something here, that what Judge Sirica had done, what McCord had revealed, and as what the U.S. Attorney's Office had done, all played a part in building a foundation for the pursuit of those at the highest levels of government. Once the Department of Justice had been compromised and where Earl was essentially isolated, it then fell to the press to accelerate the interest in the story, and here at considerable risk to the owner of the Washington Post because of the kinds of threats that had been made and the kinds of power that the president could and would exert against the economic interests of the Washington Post. They pursued the story nevertheless and deserve great credit for that. But cutting to the chase of the answer to the question of who solved Watergate, if you define solved as really understanding the roles of the various participants, including Richard Nixon, then it is the tapes and Richard Nixon's own words that solve Watergate.
Well, we'll get to that in a minute. We'll get that in a minute. Let me cut you for just a second, because I got to get to Rufus, if I may.
Thank you for leading me the next hour.
Because this is where you pick up the pieces. Because, in fact, just 2 days after Barry's story in the Post about spies, where's the money coming from, and so on, you're having a meeting with your committee chairman, Sam Ervin. You were I guess you were the Chief Counsel for the Judiciary Committee Separation of Powers Committee. Your meeting with Sam Dash, the late Sam Dash, to start planning the Senate hearings, okay? And you knew you were going to make problems for the prosecutors. Was it such a great thing, in essence, for the Senate to be saying to the public that we can't trust the Watergate investigation to the Justice Department?
Oh, no. You got to understand the institution of the Senate, and you got to understand Sam Ervin. I think most folks in here know that he's one of the best lawyers ever known to mankind, and he was picked to be the chairman because almost everybody else wanted to be on the Watergate Committee was running for the president at that time, except Sam Ervin. And Senator Mike Mansfield said, I'm going to pick the man who best can do this, who in no way will embarrass us, and who'll get to the bottom of this if you can. Actually, for all you youngsters, in fact, a week from tomorrow, it will be 38 years since the Watergate break-in. That's astounding. About half of us are dead. Half of those that died are dead. Yeah. That's what I had somebody one time in a court case say to me. He said, that person was dead. What we did, we knew this was extremely sensitive. And what Ervin always worried about meddling in the judiciary, because I had been the chief counsel and staff director, as Alan Dale and Mike Maddock and other Watergaters here know, and Judge Larry Baskier was the chief counsel of the Constitutional Rights Committee. We had studied all these things for years that led up to Watergate. It had to happen because they had been going on and on for years. I never heard you talk much about it, John, but spying on the military, that just enraged Ervin. The military had no right to spy on civilians. And the same people who were giving the excuses in Watergate gave the excuses then for all these breaches of separation of power, all this imperial presidency, executive privilege, as Ervin called it, executive poppycock. All these things were occurring and leading up to a match between Ervin and Nixon. And by the way, they were both Richard Nixon swore in Sam Ervin. I thought that was always very ironic in 1954. And Ervin never had much of respect for Richard Nixon. He disliked the way that Nixon had defeated, I think it was Helen somebody, Congress. Helen Cahagan Douglas. That had bothered him because Ervin was one time in the House of Representatives and had known that lady, and he didn't have much an opinion of Nixon from the very beginning. And then when McCord came along, because of that great work of Judge Sirica, that was our first break. And then let me tell you what happened. Right, this guy right here, let me tell you something about him. They tried every way in the world they could to destroy him. We got more letters. We got more phone calls. This guy's a phony. This guy's a fake. He would steal from his mother. Oh, God, it just was unbelievable. And we were getting up. By the time you testified, John, we were getting an average of 50,000 pieces of mail a day. Now, it's either mail or telegrams. Remember, Alan? We didn't have, remember, no cell phones, no email, no nothing like that. And our most innovative thing to detect delirious substances was a Xerox machine. Run it through there and see if there's a bomb in it or something like that. But this man came on, and I remember, was it Gurney that thought he trapped you? You said something about we met in the Mayflower Cafe, and it was some other little thing that was a Mayflower coffee shop in the Statler Hilton, and he gave amazing testimony. And my contention would be that the institution of the Senate has a different role than all these other bodies here you see. It's mainly to inform the public and to propose legislation. So we didn't have all the restraints that some of the folks here had. And we let it run wide open. There were disagreements at times, but what held it together was that Senator Ervin and Senator Baker, from the very beginning, Carl, as you well know, sat down and they said, we are not going to disagree on things. No subpoena went out from that committee, and there were hundreds of them, unless both agreed on it. I think the telling point came, as Rick said there, when that we found it was non-consequential. We thought, Rick, to bring Butterfield up. We didn't know. Nobody was much in the hearing. We were out having a party at Senator Talmadge's house. And we had this little dungeon-like room that we didn't put you in it. We put you in my office when you came up. But we had this little dungeon-like room where we interrogated people. And Butterfield was down there, and a deputy chief counsel from the minority staff asked about the taping system. And Butterfield says, yes, and I understand there was a long pause. And they came out and told us about it. And that vindicated every single thing that this man had said. So what I'm saying, Carl, is that it took a congressional committee like that with full power to really pull things together.
Well, I remember during the middle of the hearings, there was a headline in Variety magazine that said, Ervin soaks the soaps. In other words, he was drawing bigger ratings.
Oh, hell, we got more hate letters from people about knocking the soaps off the air. It was incredible.
Yeah. Hey, but
oh, my God.
Hey, I got a chance here to get confirmation on something. Earl, the New York Times reported at that point that you and Cy Glanzer and Don Campbell, your assistants, were on the verge of resigning. Was that true?
Over what?
Over the fact that the Senate had taken this thing.
Which occasion?
Which time?
We're still early now, before Cox and all that. Cox didn't come in until May. Right. Yeah. The hearings were already underway when Cox became an element. No?
I'm
just say yes or no.
Answering very articulately, because I'm just not aware of having considered resigning because of the Senate Watergate Committee.
You mean the press was wrong?
You considered resigning. I remember.
Okay, well, that was a story. And digging through some of the file on this, I saw a New York Times story to that effect. Okay, in any event, May.
If I can say, I thought the committee did a remarkable job in conducting the investigation that it did. Okay. Traditionally, just so you know, I mean, prosecutors generally do not want or favor congressional committees or civil proceedings going on because of potential interference with the underlying grand jury or criminal investigation. This case, as Senator Ervin so aptly put it, it's better that the public have a right to know than one man go to jail. That was a critical statement.
Well, wait a minute. You're speaking for yourself, but let me point out. Now we get to May. Okay, Archibald Cox has taken over the prosecution, and he comes up to the Hill, and he meets with Senator Ervin, and he meets with Rufus Edmisten and Sam Dash, and he doesn't want John Dean and Jeb Magruder to testify publicly. In fact, he says he wants the public hearings closed down.
He didn't want them televised specifically.
Yeah. Well, no, he actually added, and these are his words, it doesn't make much sense that there should be two investigations. Did it, Rufus?
Well, that happens all the time. Some great events have happened. He, as John pointed out a moment ago, he didn't want us giving anybody use immunity. And Senate Resolution 52, I believe, was one of the broadest probably ever written, and Senator Ervin wrote every single word of it himself, Rick. You agreeing that it was a broad one. I don't think there's ever been a committee that had that broad authority. And had it not had that, I don't think it would have been much anything than just a hearing of people up there staging themselves, because a lot of staging goes on in the Congress. I know that. Hell, I went back home and ran for Attorney General and won. A lot of people have done a lot of things because of things that happened on public television, Carl. But there is no inconsistency in running a congressional hearing the right way.
Well, wait a minute. Indictments, trials would have been a year away. You're supposed to shut down for a year?
Well, I'm not sure that you would have gotten that many convictions. I'm just not convinced that unless the Watergate, many of the convictions in Watergate came from perjury to our committee.
Well, Rick, come on. What do you want them to do? You want to wait for a year, or what is it you want?
Well, Archibald Cox had just been appointed, and all of a sudden, the witnesses who would be key to the continuation of the investigation into the Watergate cover-up, of course, Cox's mandate was far broader than that, were now about to either get immunized or would be testifying publicly, creating a lot of pretrial publicity. And Cox thought that his obligation was to protect the integrity of the trial and his options as prosecutor. He was wrong. It was one of his biggest mistakes, and he recognized that in later years.
Why was it a mistake?
It was a mistake because there is an independent right, a very important right of the Congress to conduct its own investigation. Here you had a Department of Justice which had been compromised. You had the opposition party of the United States broken into and wiretapped. This was a huge constitutional issue. This even before the business of what John Mitchell so aptly described as the White House horrors, the misuse and abuse of the levers of government by the President of the United States for political and, in some cases, personal vendettas. But clearly, Congress has the right to conduct wide-ranging investigations, and the fact that they conducted this investigation in open hearings with the glare of sunlight and Klieg lights on those individuals, the highest officials in the land apart from the president who came before them, was a great testament to the American democracy.
Okay, but did they harm your work?
They didn't. As it turned out, John Dean, as has been said, had a very capable lawyer, Charlie Schaffer, who sought to get immunity. He had an informal promise from Earl with respect to immunity for John. Congress conferred use immunity on John under a statute which, ironically, John Dean had written when he was Chief Counsel to the Judiciary Committee.
That's all right. Go ahead.
But I got it mostly right, I think. But Archibald Cox had as a fundamental principle of going forward announced to us, look, John Dean's culpability is signal to our going forward. You find some way to prosecute John Dean, even if it takes a year, even if it slows us down for a considerable period of time. John Dean has got to be prosecuted and sentenced. And we did find an area in which John had not given immunized testimony. We sat down with Charlie Schaffer, an old friend of Jim Neal's, who was leading the investigation at that point. I was his deputy. And we spelled it out. We said, look, this is the way it's going to be. John was caught between a rock and a hard place. He didn't rush up.
Interesting point you should know, though, Rick, is that, Richard, Charlie to this day is convinced that I had Oliver North's case before Oliver North even knew he needed a case, and that we would have prevailed. Charlie wanted to make that law at that time, and I said, listen, Charlie, I've already testified to the world of what I've done. It would be absurd for me not to plead guilty, and beating the rap isn't the name of the game here.
So to follow up on Carl's point, it didn't hurt us. The cover-up continued through the Senate hearings. Perjury was committed, as we know from the tapes, the Rosetta Stone of Watergate. Nixon specifically encouraged others to commit perjury, to claim that they couldn't recall events that they clearly did recall, as though this was a magic incantation that would protect against perjury. In fact, at the Watergate trial, prosecuting Haldeman for perjury before the committee and in the grand jury, I questioned Haldeman about the very tape in which he was, on March 21, told by Nixon, look, you go up there and you say you can't recall. And I asked Haldeman in cross-examination in the trial, what about this tape? Did the president say that to you? Did you agree? And Haldeman's answer, I don't recall.
You're all making this sound so goody-goody, but in fact, after Cox lost his plea to Rufus and to Senator Ervin and others, where does he end up? He ends up back in Judge Sirica's court, right? And he's asking Judge Sirica to enter an order with respect to immunity for these people, or at least if they're going to testify, it's got to be in private hearings, right, without the television there, and so on. So it wasn't quite as simple as you're putting it. Why? The judge said no, by the way, to the Senate. Okay, do you recall why?
To the Senate subpoena for the tapes, he said no.
Oh, that's a subsequent proceeding. I'm first talking with respect to public testimony.
The judge would not enjoin, as though he could, the Senate from acting.
I mean, he raised jurisdictional issues and so on in refusing to enter such an order, but what I'm really asking is whether or not the judge's first obligation, I don't know if Richard agrees or not, is to avoid any interference with the investigation by any party. What was Judge Sirica trying to do with this
powers argument, Carl?
The
clear separation of powers.
That was, of course, that's what he wrote.
Well, clearly was. It would have been.
Yeah. And the immunity statute does put it in the hands of the legislative body to issue or handle that immunity. They have to clear it with justice, but it is
and oddly enough,
little discretion, but it's there. And yeah.
Oddly enough, even Judge Ervin was not entirely happy. At this point, Barry, a lot of stuff is appearing in the Washington Post, particularly James McCord's testimony, which I believe was behind closed doors to the Senate committee. I don't think it was public, but Ervin described the situation that this stuff was appearing in the Washington Post as awful, terribly disturbing, he cut back on some of the information that was being supplied to members of the committee to attempt to cut down on a newspaper disclosure of what was being said to the committee by James McCord. Some of these leaks probably were coming from, I don't know this, McCord's attorney to get him a lighter sentence. Obviously, some of the stuff was coming from some of the senators who were not entirely averse to a certain amount of publicity in the paper. Did the Post have some obligation not to be used this way? You were being used by these various participants.
This was a tricky period until the period of the McCord letter. There were very few news organizations that did any reporting on Watergate at all. If they ran things, it was through the news services of the Washington Post or the New York Times. Television didn't cover it to speak of either. There's basically no coverage. But once the McCord letter came, the rest of the press joined in. And by the time of the Senate Watergate hearings, the formation of the committee and testimony, you now had a dozen or more news organizations really trying to get into the Watergate story, and did. So what Carl is referring to, they weren't just stories in the Washington Post. They were stories across the country where reporters, I guess, would call sometimes on their own senators and say, what's going on here? There were also senators who were concerned with the way the committee was going. There had been meetings, for example, as John Dean well knows, and others here, and I guess everybody now, between Senator Baker and the people of the White House. So there was a real concern that these hearings had to be straightforward, had to do what they were supposed to do on the part of members of the Senate Watergate Committee. And the reason for these leaks was to see that information came out the way, or that the hearings would go on the way they should go on. That's my belief. I think that if you're going to be critical of leaks, as many people, of course, are, I think these leaks had a justification of their own.
I wanted to go back to that point about the separation of powers issue. The judge was keenly sensitive to that separation issue, and his intent, and this was said and manifested in a lot of his actions, is to help the system, which included the press, the legislative body, and the prosecutor, work. That's why a lot of the things he did in the open, as I said earlier about the McCord letter. But in the sentencing, when he chose, and he talks about this at length, and this is something we talked about at length, he chose a statute to sentence the defendants to the maximum that would be permissible under law. And in that statute, it provides specifically, it is a tool by which the judge can get a better understanding of what would be an appropriate sentence for these individuals. Now, there was a lot going on there, but the point I wanted to make was, as a part of what, and I think it's in the record, he tells them, look, what the statute's all about, and your cooperation, your telling. He wasn't done with them yet. The trial was over. He didn't get what he had hoped for, the opening of the case up. But he wanted to give them another opportunity, and that was his last opportunity, and he said cooperate with the Senate committee.
Something that hasn't been mentioned yet, which was very, very obvious and prominent at the time, was that Judge Sirica was a Republican. He was a lifelong Republican. He was appointed by a Republican president. And the fact that this was a Republican judge, or a judge identified with the Republican Party, who was pushing for the truth to come out about the Watergate affair, was a very, very important part of this, because Richard Nixon was using every possible means to discredit those who were looking into this affair, and had politicized it to great extent. What was happening behind the scenes, as we now know from reading the tapes, about the Senate committee was part and parcel of hardball politics. And there was a heck of a lot going on, and it should not be minimized that you had the chief judge of the district court as a Republican pressing for full disclosure.
And I wanted to add to that, and I don't think I'm talking out of school here, but his colleagues on the bench at that time, all of the Democrats, said they could not do it. It could not be a Democrat that takes this case. So much for the limelight about they say the judge was seeking the limelight.
Do you know who, other than Mr. Azzaro, almost ended up clerking for Justice Sirica? Somebody want to raise their hand?
John, that's you. Who almost went?
John, didn't you interview with Judge Sirica?
Oh, that story. Yes.
Yeah. Isn't that a bit of irony in all of this when you think about it? Okay. Earl, I wanted to ask you, come on, is there anything?
One of the many ironies that after law school, my dean had sent me over to interview with Judge Sirica, who'd offered me a clerkship, and I had left it sort of up in the air because I was also being interviewed by a judge I'd met some years earlier and greatly admired. Not that I didn't admire Sirica, but Harold Leventhal. And so I actually turned down Sirica because I was hopeful of getting the Leventhal appointment. And then Judge Leventhal turned me down for the most bizarre of reasons. I had taught him how to swim and get over his fear of water. And he said, John, I'm pretty hard on my clerks, and I don't think I could come in and have the same relationship with you, who've given me one of the great pleasures in life is swimming, and have you be a very good clerk for me. So,
once again, water figures importantly in this.
Come on, Earl, I've got to ask you a bottom line question here. Is there anything the independent prosecutor's office or the special prosecutor's office accomplished that you couldn't have done?
Well, I think the answer to that is yes. They at that time just had it had become political, and as Rick said, we in the U.S. Attorney's Office we had put together quite an array, put together a lot of information setting forth the ramifications of the cover-up. And I said not only ramifications in terms of different areas, hush money, the CIA rules that Rick described, subordination of perjury, the whole litany of events. It was very frustrating to us to have the independent counsel selected because it had been a difficult period, but through various ways we had accomplished what we had set out to do in terms of the strategy we had developed. Hopefully one of those 7 defendants cracked, and we thought it might be McCord actually that would first crack, and in fact before the election in '72 we made a special pitch to McCord. I asked to speak to his lawyers, thinking that he might be the one that would most willingly come forward, and got the clearance from the department to said we would offer him a very good resolution if he would cooperate. And this was about 10 days before the election. Whether or not what I did was right or appropriate, prosecutors should have nothing to do with politics. And here I was making a pitch to a defendant to come forward prior to the election and tell us what, if anything, there was. We didn't know whether there was or there wasn't. There were indications going both ways, but we never heard back. But shortly after Carl, the McCord letter was filed, we put McCord in the grand jury. Most of his information was hearsay. We put Liddy in the grand jury, and he told us nothing. He just wouldn't answer the questions. But what we did do, and this talking about a follow-up to the press that Barry was talking about, the press started proliferating, and when we put Liddy before the grand jury, he said nothing in terms of answering our questions about who else was involved, what happened. But what we did then was to adjourn to a next-door room, a room adjacent to where the grand jury was sitting with Liddy. and his lawyer. And we just talked there for about an hour and a half, not about the case, because Liddy wouldn't talk about the case, but some very interesting subjects. But the significance of it was that the press was outside that grand jury area, and they saw us go into the room with Liddy, and they saw that we stayed there for an hour or more. And some of them reported that in the press. And when John Dean first came to meet with us, he mentioned that one of the factors that made him somewhat concerned about his own situation and what had persuaded him to seek legal advice that eventually brought him in to our office was the reports in the press about Liddy cooperating or talking with the government, even though, in fact, he never said anything. But going back to your question, Carl, about the role of the independent counsel, the matter had escalated to a point, well, let me put it this way, as frustrating as it was for us because of where we were with the status of our investigation, where we had put together most everything except we didn't have the tapes. But for that, and I don't want to undermine and underplay the significance of the tapes. They were critical discovery by the Senate that deserves enormous credit for that, and then the follow-up use by the special prosecutor was, in my view, really very skillful and very professionally handled. But it was, to put it mildly, it was very frustrating at that point. Could we have done everything? We were 3 lawyers. I don't know what the staffing of the special prosecutor was.
We were more than 3.
I'd say about 20 or 30 or more, covering a whole range of areas like campaign law violations and other areas that we weren't into. I mean, we were looking into the burglary and then the cover-up for the burglary.
Yeah. And I think that's accurate. I certainly could feel for Earl and his team because I came from the U.S. Attorney's Office in the Southern District of New York, recruited by Archie Cox and Jim Forenberg to join their team, and to see how far Earl and Sy and Campbell had pushed the peanut, not over the line yet, obviously, but in terms of developing a superstructure for going forward, it had to be extremely frustrating. The story had gotten ahead of them. Their strategy was to work at a certain level. The press was ahead of that level. Judge Sirica was ahead of that level, looking for not only did the burglars do what they were charged with, but who was responsible for sending them in there, who paid them. And then it became critical to find out how the cover-up operated. Who was paying them to keep quiet? What offers had been made to them, such as the offers of clemency by the president? What other things had been done to obstruct the investigation? How had Henry Peterson been compromised? And let me say as an aside, I could understand why Earl had tremendous confidence in Henry Peterson. When I was an assistant U.S. attorney and we had difficult issues, Henry Peterson was my go-to guy in Washington. He would support aggressive investigation, particularly where it involved political figures. And I was the head of our political corruption unit in the Southern District of New York before I came down to prosecute the Watergate case. And so at that point of the handoff, which was frustrating and was not without its human elements, it's clear in my mind that we needed that separation. Now, you had an independent counsel. The Cox, as the special prosecutor, was appointed as part of a deal. And here again, the history is convoluted because Nixon wanted to appoint Elliot Richardson as his attorney general, but the Senate required as a condition of confirming Elliot Richardson as attorney general that Richardson appoint an independent special prosecutor to investigate Watergate. And so the charter was created that gave Cox independence. And Archie Cox, who had been Elliot Richardson's law professor at Harvard, was selected, not his first choice, incidentally, but selected to begin the investigation, and assembled a staff of lawyers. We were broken into different task forces, one of which was charged with investigating what we call the Watergate Cover-Up.
Barry?
Yeah, I wanted to make a remark about people like Henry Peterson and Kleindienst, who were compromised to a great extent during this investigation. There are others also, but there came a point when they said, I've gone this far, but I'm not going any further. And instead of being compromised, they came out very strongly for justice in the Watergate case. It was after, I guess it was after the Ellsberg break-in was revealed, the two of them forced Nixon's hand totally on what would be admitted and what wouldn't be admitted. And it's a very human characteristic that was at play here in Watergate, where people took part in a conspiracy and then said, that's it for me. I'm done as a conspirator.
When I think of who solved Watergate, I think not necessarily just of John Dean or Judge Sirica or Sam Ervin or Alex Butterfield or what. I think of Richard Nixon. I think of the Saturday Night Massacre, and that raises an institutional question, which is at the very outset, the suggestion had been made, a suggestion which was later followed in the independent prosecutor law, the Senate was suggesting that judges of the D.C. Circuit, or the Court of Appeals of D.C., appoint an independent or special prosecutor, so someone who would not be subject to any presidential influence. And this whole thing might have turned out entirely different if that process had been followed. With no particular order here, is there anybody who wants to respond to that? What difference did that make? Was it a fatal mistake, a big mistake, at least for Richard Nixon?
Well, Richard Nixon made every wrong move at every possible juncture. Otherwise, he would have survived as president. But once the tapes were revealed, and Henry Peterson, again, revealed to Archibald Cox early before Butterfield's interview by the Senate staff, that he thought there was a taping system because Nixon had talked to him about John Dean getting immunity. And Henry said, look, Dean has not gotten immunity. And Nixon said, you want to hear it on tape? And so Peterson revealed that to us, and so it became part of the script.
Well, of course, Sanders has asked the question because Nixon's own performance, as Baker later did me, he was so awkward in handling his taping process. In one conversation I have with him on April 15th in his executive office building office, he's first of all asking me a series of leading questions, which is very unlike our normal conversations where he's looking for answers and not getting the answers he wants. For example, at one point he said, well, you know, John, you told me there was cancer on the presidency and these guys were asking all kinds of money, and I asked you how much, and you said, well, it could cost $1 million. And I said, well, you know, John, that's no problem. And of course, you knew I was joking when I said that. And
Never mind.
And then after that, he got up and literally went to the corner of his office where there was a potted palm, and in a large stage whisper, he says to me, John, I was foolish to talk to Colson about clemency for Hunt, wasn't I? And I said, yes, Mr. President, you were. At that moment, I said, this man is recording your conversation. And I would testify this about this before the Senate committee. This would in turn provoke the question by the Senate of Butterfield, and as they say, the rest is history. And what's interesting, I almost left that out of my testimony.
And this became part of the script for questioning every White House witness. Was there a taping system? Do you know anything about tapes? And bingo, one of the literally handful of people who knew about the existence of the taping system was this middle-level person, Alexander Butterfield, former Air Force colonel, who told the truth. And so once we knew about it, both the Senate and the Watergate Special Prosecutor pursued subpoenas, because obviously this would be the best evidence of what was known and what was actually said. The Senate was turned down by Judge Sirica.
Yeah, we're still mad about that.
And the Watergate Special Prosecutor's subpoena was enforced by the court, upheld by the court. The D.C. Circuit then affirmed Judge Sirica, and the Saturday night massacre occurred. And from my point of view, even though the Senate hearings had garnered great attention, the crisis that was created by the Saturday night massacre, in which Archibald Cox was fired, but Richardson, the Attorney General of the United States, resigned rather than follow the President's order to follow Cox. The Deputy Attorney General of the United States, Bill Ruckelshaus, refused the order and was fired. And Robert Bork, the Solicitor General of the United States, eventually issued the order to fire Archibald Cox.
Other judges actually got a piece of this action. Judge Gazelle was asked in a lawsuit by 3 members of Congress, and I think Ralph Nader, to reinstate Cox. Mm-hmm. Did you want that? Or send Jaworski home, or what did you want?
Well, we were not a part of that.
He didn't order
Judge Gazelle ruled that the firing was illegal. But at that point, Leon Jaworski had been appointed and had taken over, and Cox really was not interested in disrupting what was happening. In selecting Leon Jaworski, remember, Alexander Haig, the President's Chief of Staff, was part of the continuation of the cover-up. And Cox, we know that, again, the Rosetta Stone, the tapes. And I commend to you who haven't done so, take a look at Stanley Cutler's book, Abuse of Power, in which he has done tremendous work in transcribing hundreds and hundreds of tapes. A very difficult process. He doesn't get them all right, obviously. But this is a most fascinating read, indeed an integral read for those of you who really want to get to the gist of what was happening in Watergate and what was going on behind the scenes. But the court's saying that after the Saturday night massacre and the firestorm of reaction to this extraordinary event, and Carl Stern reported on it from the lawn of the White House, which I saw that evening and then rushed down to our office where the FBI, including the same agents who were working for us that morning in conducting our investigation, were now, on the President's orders, occupying our office and refusing anybody access to the files.
And reporting to Henry Peterson.
Right, right.
Yeah, but more, I think more importantly for me, and Richard was there, and to understand and to feel what a young lawyer is facing when these guys are coming through the door like this, and under the circumstances and the aftermath, and holding that team together. He just goes by and says the crisis and all this, and then we move on. There was tensions, and there were experiences, and there was character in that room that kept that team together. And that's a story that you ought to hear about because someday you may be facing that.
The headline on my story that night was Richard Nixon jumped tonight from the frying pan into the fire.
Yeah.
That's true. And then, and I was saying is that the appointment of Leon Jaworski, who was a Democrat, but a Democrat who had worked for Nixon's re-election in Texas, who was very close to John Connally, who was one of Nixon's closest confidants at that time, aroused great suspicion among the staff. And Leon worked hard to overcome that suspicion. But, we thought that this might be the greatest fix of all time. Now Cox was out. Jaworski was in. Who knew what was on these tapes that eventually had to be produced because of the firestorm of public opinion? So you had the prosecutors, Earl's office, the U.S. Attorney's office, the press accelerating, the Senate having open hearings and leading to the disclosure of the existence of the tapes, the firestorm created by Cox, who would not back down and would not accept a rigged proposal that Nixon put forward, the so-called Stennis Compromise, where we would not get the tapes, but we would get some authentication by Senator John Stennis, who was along in years. I think he was 78 years old. Anybody who's listened to a tape recording, one tape recording, knows how difficult it is to make it out. Stennis had been grievously injured, I think 8 months before, and he was shot on Capitol Hill in a mugging and had a very serious medical procedure done. And who was going to help get Stennis through the process of authenticating these transcripts that the president would provide? Fred Bizarre, counsel to the president. So the whole thing would not sit with Archibald Cox, who said, no, I want the tapes. And that led to Nixon making the decision, which he had discussed for weeks beforehand with Haig and others, to fire Cox. Nixon thought this was the solution. He would get a new replacement to take over. Eventually, Leon Jaworski was hired. But once Leon heard the tapes, which were turned over, because in addition to all the other elements of this, now the public plays a great role in ensuring that the investigation moves forward and that the Saturday Night Massacre doesn't succeed in its purpose, and we get the tapes. Once Leon heard the tapes, in my view, including the March 21 conversation, the so-called cancer on the presidency conversation, in my view, it was over. Richard Nixon could not continue as president.
I got to ask you two 10-second questions. John, you once told me about 35 years ago that you believed Warren Burger had assured the White House that the White House tapes would never be made public. Am I mistaken?
I don't recall saying that, but I do recall why I might have said it, and that is that when Warren Burger was selected Chief Justice, he got the impression that he would have the right, first of all, to select any of those who would follow him to the court, and had a huge influence on telling, first of all, typically John Mitchell, but sometimes the president himself, who he thought might be on the court. He did find out how to bridge that constitutional separation of powers by picking up the telephone and talking to the president from time to time, and did have some influence. I say some because, to me, the classic case was when, in '71, Nixon was considering placing a female, the first woman on the judge, Mildred Lilly, who I vetted. Burger threatened to resign if a woman came up there. And Nixon said, send his resignation right on down. Give Nixon credit.
Another quick 10-second question. Rick, in your new book, you have a theory as to what was on the 18.5-minute gap.
Well, once we learned that there had been an alteration, which eventually, and again, all of these events stand out, but perhaps most vividly in my mind is the hearing over the 18.5-minute gap. How did this happen? What was on it? We convened a panel of experts who invented a new procedure, a technology for developing audio tape, in which they concluded, and this was a panel picked jointly by the special prosecutor and the Nixon White House. They concluded that the 18.5-minute gap was the result of at least 5 and perhaps 7 or 8 independent manual erasures. So this hearing, which gave the Nixon administration, from Alexander Haig on down, who testified in open court before Judge Sirica, the opportunity to be cross-examined about the handling of these tapes, gave Nixon a choice between incompetence or venality. And obviously, incompetence was the rule. And this gave the lie to the notion of the efficient White House, the Haldeman, Ehrlichman, German Shepard's notion that had prevailed, that Nixon, while ruthless, was not stupid. Nixon could not have done anything, or his administration couldn't have done anything as stupid as break into the Democratic National Committee headquarters. And so this played another important role in the building blocks that led to Richard Nixon's eventual resignation in the face of certain impeachment and conviction, but also, again, providing us all here, and historians and others, with irrefutable evidence relating to not just the Watergate break-in, but a variety of abuses of what we have here all described as an imperial presidents.
Okay, we have solved the question, who solved Watergate? The press, Earl Silbert, the Irvin Committee, and Rufus Edmisten representing it today, John Dean, Rick Ban-Veniste, and Richard Azzaro representing Judge Sirica. My choice, as I mentioned earlier, was Richard Nixon because of the Saturday Night Massacre. And therefore, you have the question answered. I have been instructed by the court that we're out of time, much as we would have appreciated your questions. So with that, I believe this portion of the program is over. And thank you to our panel that traveled great distances to be here.